Hey YouTube fam, what's up? It's your girl GlamCam, and I had to come with this video because this is based on the newest hearing for Jarvis Butts. Very disturbing. This is based on different victims. It seemed like two victims of what they described with the different type of docket numbers they was given. I was trying to hear the video more closer, but it's kind of giving muffled. Somehow Michigan got them type of courts where the speakers, the microphones just ain't giving what it's supposed to. So I'm just trying to listen as clear as possible. You know, you guys can put your input in the comment section too, if I might be hearing it wrong or hearing it right. But I know this case is getting very twisty turny, but just hear me out real quick before I show, because I know I didn't hear what I thought I heard. I need you guys in the comment section, like, please letting me know. I could have swore I heard this judge say that the victim said they were in the bed with their dad when they were asked from the prosecutor who was in the bed, which they was like they dead. This is what the judge is going to read out. So I'm just like, we know some of his daughters are possibly victims. I only know of one. I don't know of, I'm talking about from what we heard from court hearings, testimonies. And now it's to the point, man, this is just, it's aching me in the worst way. Because I don't want them playing in them courts when it comes to this situation. Like, it's still justice for Naziah. That's what it's for. I want all the justice for Naziah. And also all the justice for the victims. So just because they lower something now on this charge, no, it's no way they can, don't let him get off on nothing when it comes towards this trial for Naziah. No, because right now they trying to nitpick of what they can confirm and what they can't confirm. And he still gets to wear a mask at that. Looking all type of crazy, sick. So this person and these victims, they need the justice, like seriously. Why is we even at a hearing trying to lower his charges? Like, that's what I don't get. But let's get into this of what this judge was saying, because I want y'all to hear it out. If I know I'm hearing it clear, okay, I know you guys gonna hear it. Make sure you click like and subscribe as well.
Next page, page 84. Question, okay, where were you sleeping? Answer, I was sleeping in the bed with him. Question, you were sleeping in the bed with your dad? Answer, yes.
Okay, YouTube fam, I'm sure you guys all heard that, what that judge said. Now that's some very sick, disturbing stuff. It's giving automatic life in prison to me. Like, I don't play about the kids. Like, you violating children. Why is the adults in there even having a back and forth argument about that? Of trying to get the charges low. It doesn't make sense. And then they got him listed on there like the suspect of the Naziah Harris murder. Like, in one, I remember in one of the articles they had in the connection of the Naziah Harris murder. So it's like these hearings, everything give like bits and clues of everything. But at the end of the day, we know he's a monster. He's a sick monster. Shouldn't even be having a hearing. We need to be getting to where is the recovery of Naziah. Like, we actually need to be knowing that. I want to know some details. I want to get updates on that. You get what I'm saying? Like, where's the updates? This is so heartfelt. So right now I'm just going to dissect little bits and pieces of the case. So the part I'm finna show now is the beginning of this hearing. And I just want you to hear this defense attorney, how he don't want to make it a big deal of just what he done to that child for the jurors. Like, oh, he didn't penetrate, you know, he didn't do that. What part can she identify? She talking about the part she urinated at. Like, it doesn't matter. He's a sick man. Okay, just listen to it.
With Mr. Butts and Mr. Butts' girlfriend. At some point, the girlfriend left the bedroom. Mr. Butts was in the bedroom. She was on the couch. Mr. Butts summoned her to the bedroom, at which point she was ordered to take off her clothes. Her testimony was she took off all her clothes except her underwear. She took off her clothes. Then Mr. Butts touched her. I believe the order of touching her was he touched the top of her thigh, then he touched under her breast, and then she said he touched her where she peed. Okay. That was the sole testimony of this witness. At the end of the proofs, prosecution moved to bind over on an original count of criminal sexual conduct in the second degree and added a count of criminal sexual conduct in the first degree because of the statement of because of the statement of complaining witness. Your Honor, we believe that is an abuse of discretion. The only thing that we have on the record is she said she touched where she uses the restroom, and the only clarification we had was she said this is where she pees or she urines from. Excuse me, those were her words. From that, we have the prosecution postulating that meant that there was some penetration, except there was no penetration mentioned. There was no penetration discussed. We know from case law, for a CSC 1 to happen, there has to be some form of penetration.
Like, it should be no possible way that they up in there defending that man. Whether he did the penetration or just touching. That is just plain old sick. There's no justification for that. It's like we should not have his charge lowered just because you feel like it wasn't penetration. Just because that child couldn't specifically describe what was taking place. This is a child, a scared child, afraid. And you want to defend this predator? And just because it's not of penetration, like that's a whole adult, that he need his charges lessened? That what pissed me off in the worst way.
Even the slightest. Case law also tells us if she testified that he were to force her underwear inside of her, that would be sufficient for penetration. Yeah, we don't have any of that. We never have conversation, or we never have any testimony about her panties being pulled aside. We never have any testimony about her panties being forced in her. We never have any testimony about anyone penetrating her. Now, that is given the fact that she was 4 years old at the time this happened, granted. But at the time of the hearing, she was 13.
So the victim was 4 years old, saying what happened when when it started at 4, and now 13 years old at the hearing. And allegedly, we know that Jania's possibly 13 right now. Yes, she is. So allegedly, we don't know if this is her, but from what we heard in the beginning of the video, when the judge said dad, I'm just saying, this defense attorney is definitely pissing me off. Okay, so let's get back into a little bit of what he's saying.
Surely she could testify. I believe she was asked on direct that she remembered the events, and she said she remembered the events. None of that was testified. I think to say that there was sufficient evidence on the record that says that there was a penetration for the purpose of the CS1 is an abuse of discretion, and we believe that should be dismissed.
Thank you. And counsel, your respective motions, they're similar in nature in that you're arguing the issue of whether or not there was sufficient evidence on the issue of penetration on both your motions for quash, correct?
Correct.
Okay. Do you want to, why don't we have him argue his, on the second matter, and then we'll hear one response from the people if you're okay with that?
That's fine.
Okay.
Okay, so this is then with regard to the case ending in 24101. And sorry. Okay, and this is Lauren Butler, P88126 again. So first, to overview the facts from that case, I want to emphasize that this is only with regard to one of the two instances described. The complainant described two instances, but only one of them has been charged as first degree. And I am only arguing with regard to that and that particular charge. So at the preliminary exam for that instance that was described, the testimony included wearing panties. So again, that is similar. She never described those being removed. She did not describe any instances of penetration and only described light touching while wearing panties. The prosecution had the burden at the exam of establishing evidence of every element, and that included penetration. And again, the case law is clear on this. In particular, the case I cited in my motion, People v. McNeese, while that is unpublished, it is particularly relevant because it highlights this distinction where it needs to be more than just, it uses very similar language to that used at the exam here with this emphasis on touching the vagina, rubbing the vagina. That's not enough for penetration. And there was even a specified testimony about under the underwear and over, and yet even with that fact, the court still held that this was not penetration. And that's similar to what we have here, this description of some degree of touching of that area, but that alone is not penetration. It also relies on published case law, People v. Payne.
They tripping for real, and they just giving the description of anything that ain't the P word, penetration. Anything that's not that, just to justify that they don't need to be first degree, trying to lower it. Anything to give a description that they don't need to be first degree on a little child. And that thing, crazy thing, just sitting there with a mask on, blinking repetitively with all kind of sick thoughts in his head. You could just see it, and it's just disturbing. Okay, let's just get into a little more.
Rubbing one hand, where it concludes that rubbing one hand over another vaginal area does not qualify as penetration. And I'd also like to address the response from the prosecution to this motion, because the argument they're making was not reflected in the preliminary exam testimony. Specifically, there was no testimony about inside the vagina. So while they're now arguing that that is possible, it's not the testimony we heard. We didn't hear this contrasting of the labia and the vagina. And this diagram that is now referenced in the motion was not used at the exam. So in conclusion, the prosecution did not meet the probable cause standard for first-degree criminal sexual conduct because there was no evidence of penetration, and bind over was not proper, specifically as to that charge.
Thank you. All right, who's going to take the lead from the people?
That's me, Judge.
All right, very good.
So I'll start with the first argument made by Mr. Riggins, the complaining witness there, reference her by initials PB. She testified specifically that he touched my private part where I use the bathroom with. When asked what comes out, she stated urine. I then asked, tell me about what part of him touches you there. She states his hand. And what does he do? What does his hand do when he touches you there? She states he rubs my private part with his hands. I then clarified, is this on the top part of that? And she interjected, she said the bottom. And I said, would that be where the pee comes out? She says, I clarified, is that a yes? So in summary, she testifies he's rubbing the bottom part of her private part where the pee comes out. Your Honor, in a motion to quash, this is the highest deference to the reviewing magistrate in this case. It requires an abuse of discretion, which is most deference to the district court. Penetration requires any sort of intrusion, however slight. And we use the term genital opening rather than vagina, so that penetration of that labia majora is sufficient to establish penetration or criminal sexual conduct in the first degree. Here, the complaining witness testified that the defendant rubbed her on her bottom part where the pee comes out. When we think about basic anatomy, we know that pee or urine for women comes through the urethral opening. There's a lot of, biological anatomy down there, but we know that the urethral opening is an internal structure that's beyond both the labia majora and the labia minora. So when this complaining witness testifies that he rubbed her bottom part where the pee comes out, she's referring to an internal structure, thereby penetration. The examining magistrate also found that, and so in her ruling, that for a woman to urinate, it's not on the outside of her labia. That's an internal. That would be beyond that. And so she found that it was a question of fact. I don't believe that there's any abuse of discretion by that. I believe that there's satisfactory testimony, at least to a probable cause standard, for that count.
Okay, on this part coming up, pay attention to when she say, "You want me to go on to the next one?" And he's going to be like, "Yes." So she's going to describe some more what the sick man Jarvis Butts was doing. So now she's going to speak on, another situation. And then I'm just trying to get to my understanding, is this another victim? Two separate situations. Because the beginning, the defense attorney was like Jarvis Butts' girlfriend and, the girlfriend's daughter. And then we hear the judge say, the girl said she was in bed with her dad. So I don't think, are these women got their kids calling him dad, like as soon as they get with him? I'm just trying to see, but it's so sick. But let's just get into a little more.
And do you want me to go on to the next one?
Please.
Okay. In the second case, extremely similar. This one is specifically, this complaining witness starts off with "feel them in your ear," like this or something. We don't have what she was demonstrating, but she's playing with her ear. He was doing that to my vagina when I woke up, and I was crying. I stated, "All right, when you wake up to feeling something?" She said, "Yes." I asked, "Where do you feel something at?" She says, at my vagina. And I said, "What do you feel at your vagina?" Should I feel like somebody's playing with me? Like, I don't know, like somebody's trying to touch you but not wake you up while he's touching you. And I said, "What part of him is touching you?" She said, "He's using his hands." She later confronted the defendant about it. He's asked her why I was acting so weird towards him. She said, "You don't remember what you did to me?" The defendant looked me dead in the face and said, "I don't remember doing that, but if I did do it, then I'm sorry." Again, the reviewing standard is abuse of discretion.
Okay, so I clearly heard similar situation, different case. Okay, so this is a whole different person, went through the similar things, and you can tell that this victim is telling the truth, because we all know that Jarvis Butts is a high-profile manipulator, and he manipulates weak women and children. Children can't help themselves, but he goes for insecure, weak women that don't got no type of backbone, vulnerable, and that have children. So what this witness said, it sounds just like something Jarvis will say. "I don't remember doing that. I'm sorry." He got a pea brain.
And here, similarly, she testified that she felt the defendant at her vagina, that she felt the defendant playing with her, using his hands at her vagina. It's more than just mere contact, mere brushing against a vagina, or just merely touching on top of it. It's an intentional act at her vagina. By stating she felt the defendant's hand at her vagina, she's testifying to penetration. She did not state that she felt his hand on or over her vagina, but rather at her vagina. Again, we look at basic anatomy, Judge. The vaginal opening is beyond beyond or inside both the labia majora and the labia minora. And so because sexual penetration is defined as the labia majora and beyond, the vaginal opening is beyond both the labia majora and minora. And so by stating that she felt the defendant's hands at her vagina playing with her, she testified to penetration. and I believe that there is satisfactory testimony on the record to satisfy that to the probable cause standard, which is, again, probable cause standard is the lowest standard, and abuse of discretion is the highest deference to the examining magistrate. And I believe that they both create questions of fact.
Thank you. Did defense wish to respond?
Listen to this defense attorney, y'all. Now he gonna boil me. He boils my blood. He is too concerned with how the jurors gonna look at this monster, feeling that it's not fair for this monster, or how the jurors look. We already look at him as the worst. Okay, that should be enough right there. All that was described in this hearing should be enough as well. Like, I'm telling you, it's too much. But I want you guys, that's what he's about to say. So I want you guys to check it out and hear this defense attorney. We're going to leave this video off here. I want to thank you guys for watching. Make sure you click like and subscribe. And there's always justice for Naziah. Her birthday is about to come up, August 16th. Her mentioning her name and just knowing that there's some victims out there that finally got a voice now, and it's only right to mention them too. Like, just know that we hear them and we know that they went through that. It's just messed up how the law works. He really get to set up in there while we don't have Naziah recover. He get to set in there while people have this trauma, children have this trauma they're left with, all because of this monster.
Your Honor, in all seriousness, we're giving far more biology of the human anatomy that would ever put on the record at the preliminary examination. All we had at the preliminary examination they were touched at the area. We have young ladies who, although at the time this happened, may have been too young to describe the actual part. At the time of the preliminary examination, surely they could have said, he touched me on the inside. He forced my panties aside. He touched me on the inside. And in either case, was that testimony ascertained, that testimony was given, that question was asked by either people. So here, all we have is hyperbole. This is what the complaining witnesses must have meant when they said that. Yeah, and I think that is a far reach, and I think surely that is an abuse of discretion to just simply say they must have meant there was internal penetration. That is an element the prosecution has to prove in each and every case when they charge a CSC in the first degree. In neither case was that proven, was that ascertained. We just have speculation, and to put those charges in front of a jury would simply be wrong, Your Honor. So we're actually to grant both motions.